All right, so that case is Nessa Clark, cause number 332-800. Has been transferred to County Court at Law number 3. Court had a conflict of interest. Court previously represented Ms. Anissa Clark. And so that case is being transferred to County Court at Law number 3. When I call your name, please come before the bench, stand on the X. First person is Martel Francois. Mr. Francois, is your full name Martel James Francois Jr.?
Yes, sir.
Mr. Francois, would you please raise your right hand? Mr. Francois, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
You may put your hand down. How you doing, Mr. Francois?
Yes, sir.
I'm doing fine, thanks for asking. Mr. Francois, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Francois, do you recognize this document?
Yes, sir.
And Mr. Francois, on page, at the bottom of this document, is this your signature?
Yes, sir.
And are these your initials on the top of this document that
Yes, sir.
state you would like to, you want to, your case reset to hire your own attorney? Okay, Mr. Francois, before you signed and initialed this document, did you read the document? And well, hold on a minute, let me, Mr. Bailey, Mr. Francois, you're gonna have a seat at that table, right there, and you can sit down and read that document, and then when you finish, we're gonna call you back up. Next case is cause numbers 323, 227, and cause numbers 332, 425. Both cases are styled the state of Texas versus Samuel Hayden Falk. Mr. Falk, would you please come forward? Would you please raise your right hand? Mr. Falk, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Mr. Falk, your full name is Samuel Hayden Falk?
Correct.
Okay, Mr. Falk, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Falk, do you recognize this document?
Yes, sir.
And Mr. Falk, is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line stating you like to apply for a court-appointed attorney? Excuse me, that you would like to have your case reset so that you can hire your attorney.
Yes, sir.
Now, Mr. Falk, before you signed and initialed this document, did you read the document?
I'll briefly one over.
Okay,
I can
well-
go over it again.
Okay. Okay, you can have a seat at the table and read it. Okay, Mr. Francois, you finished reading that document?
Yes, sir.
You can come on back up and stand on the X. Thank you. Mr. Francois, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line stating you'd like to have your case reset so that you can hire your attorney?
Yes, sir.
Now, Mr. Falk, excuse me, Mr. Francois, before you signed and initialed this document, since you signed and initialed this document, have you read this document?
Yes, sir. Yes, sir.
And did you understand what you read?
Yes.
And is everything in this document true and correct to the best of your knowledge? Okay, now, Mr. Francois, you stated that you would like to have this case reset so that you can hire your own attorney. And your case is going to be reset. You're going to stand on the far X in front of our court coordinator. She's going to reset your case. And once you reset your case, you'll be free to go and you have a blessed day. Mr. Falk, have you read that document?
Yes, sir.
Well, that's it. Now, Mr. Falk, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without an Attorney. Falk, do you recognize this document?
Yes, sir.
And is this your signature on the line entitled defendant?
Yes, sir.
Are these your initials on the line stating that you'd like to apply for court-appointed attorney? Excuse me. Is this your initials on the line stating
Yes, sir.
that you'd like to hire your attorney?
Correct.
Now, Mr. Falk, did you read this document?
Yes, sir.
Did you understand what you read?
Absolutely.
And is everything in this document true and correct to the best of your knowledge?
100%.
Okay, so Mr. Falk, you want to get that to her?
I'm gonna apologize to the court that it didn't work out with my previous attorney, Mr. Smith.
Oh, well, that's
We've
not a,
been dragging this on.
okay, Mr. Falk, let me do this here. Mr. Bailiff, would you? I give you, hold on a minute. Now, Mr. Falk, you've just been handed a document that is titled Standard Bond Conditions in County Code at Law Number 2. Do you see that document?
Yes, sir.
And Mr. Falk, I'm going to go over this document with you. And it reads, following arrest and or accusation in County Court at Law Number 2, Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Correct. Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. And that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, Section A2 and Section C2. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4, this will apply to you because you have a DWI second, which is classified as a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. Now, and condition number 4 states, the defendant who has been arrested or accused of any subsequent offense listed under section 4904 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator. And said device shall be installed at the defendant's expense with written verification of such installation being submitted to the court on or before the 10th day after today. And okay, that's the document says any vehicle that you own or operate. Okay, so if any vehicle that you own or operate must have an interlock device mechanism on the vehicle. Okay. Now, do you understand these conditions, Mr. Falk?
Yes, sir.
Now, Mr. Falk, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest, and you could be placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, Mr. Falk, your case is going to be reset to give you an opportunity to hire an attorney. Our court coordinator is going to give you that information. Once you get that information, you'll be free to go on. You have a blessed day. Please stand on the 4X.
May I say one thing?
Okay, let me do this here before you make any
Okay.
statements. Any statements that you make can and will be used. You have, first of all, you have a right against self-incrimination. Any statement that you make can and will be used against you in a court of law.
Correct.
And so,
I'm okay with it. I wanted to apologize that the last time I wasn't here for your court date. I had called the bond office on Monday morning to check. I knew it was Wednesday of that week. My mom was scared it was on Monday. I called the bonds office and the woman up there told me that I had no court date. And that's what led to me getting the warrant. So I wanted to apologize about that. I should have been more thorough. I don't know. I thought that they would be.
Well, you'd have to take that up with your bondsman.
Oh, it's okay. I
All
just
right.
wanted to apologize.
All right, your
Thank you,
apologies, okay. Jonathan Baldwin. This is cause number 325-002, case of South State of Texas versus Jonathan Baldwin or Jonathan Jamal Baldwin. Mr. Baldwin, is that your full name? Mr. Baldwin, would you please raise your right hand? Mr. Baldwin, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Baldwin, you may put your hand down. How are you doing, Mr. Baldwin? That's good. Mr. Baldwin, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Mr. Baldwin, do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line stating that you'd like to apply for a court-appointed attorney? Now, Mr. Baldwin, I also have another document. This document is titled Jefferson County Affidavit of Indigence. Mr. Baldwin, do you recognize this document? On page 2 of this same document, Mr. Baldwin, there is a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Baldwin, before you signed and initialed these documents, did you read the documents? And did you understand what you read? Okay. Now, Mr. Baldwin, let's see. First document, affidavit of, now, which document didn't understand? Was it both documents or one document? Oh, the affidavit of indigence? Okay, so it states that first it has, you ask your first, middle, initial, and last name, and it has that information on there. Let me do this here. I'll go off the record pursuant to Article 1.24 of the Texas Code of Criminal Procedure. All proceedings and trials should be public. However, pursuant to Lilly versus State Southwest. Let's see, Lilly versus State 365, 321 Southwest 3rd. All public trials. The right to public trial is not absolute. It may be outweighed by other competing interests, such as interest in security, also non-disclosure of public information, or that the right ensure that the defendant receives a fair trial. And the court is inclined to close these proceedings because it may be to prevent the disclosure of non-public information, in that this information that is on the defendant's Jefferson County Affidavit of Indigence that the court is going to go over. Also, the closure is no broader than necessary to protect the defendant's interests. The court has considered other alternative means of closing the proceeding. And the court makes these findings, and these findings are adequate to support a closure. So at this time, this portion of the proceedings will be closed to the public to prevent the non-disclosure of public information.